One of the terribler things that occurred was the Supreme Court's decision in the wee hours of Thursday morning, declining to stop a Texas law that bans abortions after about the 6th week of pregnancy. And that's what I want to talk about during this first segment, because there is more. I mentioned this the other day. There's more here than just banning abortions in Texas. The Supreme Court itself decided that the Constitution of the United States is no longer operable and made this decision. Let me explain. Matter of fact, rather than my attempts to explain what I'm trying to say, let me turn to Erwin Chemerinsky. He is the dean at the University of California, Berkeley School of Law. He's also a distinguished professor there. So rather than my struggling to be coherent about what I feel needs to be said, I want to turn to what he has said in the Washington Post. All right? So this will be primarily direct quotes from Professor Chemerinsky. He writes, the Supreme Court's decision in the wee hours of Thursday morning declining to enjoin a Texas law that bans abortions after about the 6th week of pregnancy immediately prompted the reaction that Roe v. Wade is dead and Roe v. Wade got overturned. But Roe v. Wade wasn't expressly overturned. That landmark 1973 ruling was, as former Secretary of State Hillary Clinton tweeted, gutted. The insult to the injury of the court's decision is that a 5-4 majority didn't countermand the court's own holding in Roe. Instead, in a cowardly unsigned opinion, members of the majority, over the signed dissents of Chief Justice John Roberts Jr. and the court's 3 liberal justices, declined to carry out their central and sacred functions, which are to protect constitutional rights and uphold the rule of law. The court ruled in Roe that the 14th Amendment's due process clause contains an inherent right to privacy, and that right, as Justice Harry Blackmun wrote at the time, quote, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy, end quote. The Roe court also precluded states from prohibiting women from having abortions before viability, when a fetus would be able to survive on its own outside the womb. In 1992, the court affirmed Roe v. Wade in a case titled Planned Parenthood versus Casey. The Texas law at issue now, in clear violation of Roe, prohibits abortions after a fetal heartbeat can be detected at around the 6th week of pregnancy, a time when many women don't even know that they are pregnant, and many weeks earlier than science has found that a fetus would be viable. It's been estimated that this will preclude as many as 85% of abortions in the state, many, if not most of which, are the legal right of the women seeking them. Beyond that, to thwart the Constitution, which is supposed to be the highest law in the land, the Texas law enlists private citizens, even those with no connection to a woman seeking an abortion, to enforce its unconstitutional ban by giving them the right to sue anyone who performs an abortion after about 6 weeks of pregnancy, with an award of at least $10,000 for successful suits. In effect, in Texas, there is now a bounty on many of those exercising their constitutional right to choose to have an abortion, But the court's majority said nothing in defense of the Constitution or its own role in enforcing it. The Supreme Court can and probably will overturn Roe v. Wade. But until that happens, it is the law, and all citizens in all branches and levels of government, including courts, are bound by it. The appropriate action in the current case, Whole Women's Health versus Jackson, would have been for the court's justices to enjoin the Texas law from going into effect at least until they reconsider Roe on its merits. By failing to do this, the court's majority, Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Barrett, effectively said that Texas is free to flout the Constitution and that the High Court itself is powerless to defend the Constitution of the United States. As Chief Justice Roberts pointed out in his dissent, the court's decision, at a minimum, quote, cannot be understood as sustaining the constitutionality of the law at issue, end quote. And as Justice Sonia Sotomayor made plain in her dissent, quote, presented with an application to enjoin a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny, a majority of justices have opted to bury their heads in the sand, end quote. She added that the Texas law, quote, is a breathtaking act of defiance of the Constitution, of this court's precedents, and of the rights of women seeking abortions throughout Texas, end quote. She comes very close to saying that 5 of her fellow justices endorsed lawlessness. If you follow Sotomayor's point to its logical conclusion, states could undermine any constitutional right, the right to bear arms or the right to same-sex marriage, by attempting to revoke those constitutional rights and authorizing and even encouraging private citizens to sue anyone who exercises those rights. The Texas legislature, of course, wrote the law this way to make it harder to challenge it in court. If state prosecutors play a role in enforcing this clearly unconstitutional statute, they can be sued for an injunction to prevent them from doing so. But since the law is not being enforced by government agents, Texas is impeding legal challenges. And under this view, the way to challenge this law would be for a doctor to violate the letter of the law, be sued, then forced to argue in court that the law is unconstitutional, which it is. But that is lawlessness. You don't have to violate a law to demonstrate its unconstitutionality when that law, as written, violates an already enshrined constitutional right. Rather than waiting to adjudicate the Texas law on its merits, members of the Whole Women's Health majority tossed out, as Chief Justice Roberts explained, quote, very old and very important legal wine. The ability to ask the judiciary to protect an individual from the invasion of a constitutional right, end quote. They handed the Constitution's power, they being the Supreme Court majority, to the Texas legislature and a gang of waiting bounty hunters. They have the authority and enough votes to reverse precedent, explained their legal reasoning in a signed opinion after briefs and oral arguments, and to revoke reproductive rights, however flawed such a ruling might be. But they didn't do that. The majority was mute on the right to privacy. The majority abandoned its constitutional role and held indirectly but unmistakably that the Constitution of the United States is a mere inconvenience that states are at liberty to violate if they can come up with cunning statutory language. Even though Roe v. Wade is still the law, women in Texas no longer have the right that it protects. That has no resemblance to the rule of law. See what I mean? Professor Chemerinsky didn't use the F word once, didn't scream and froth at the mouth, which I guess is hard to do when you're writing something. But the dean of the University of California, Berkeley School of Law, made the case about as clearly and eloquently as the case can be made, what these Supreme Court justices are about, with the help of Christian fascists like the Texas legislature. And there will be more of these cases, this law, the Texas law, being written in all sorts of states across the union now. You know this. But what the Supreme Court said is just like Professor Chemerinsky pointed out. I'm sorry, Chemerinsky, I'll get it right. That any constitutional guarantee now, such as Roe v. Wade, the right of a woman to privacy, which was what Roe v. Wade was about. It wasn't about a choice. It was about a woman's right to privacy as contained in the 14th Amendment, the Due Process Clause. That's why I've said so many times, I wish that the advocates of a woman's right to privacy would have captioned it or titled it like that whenever they talk about it. Because how are you going to say a woman doesn't have a right to privacy? Well, you can't say that. I mean, you can, but it immediately identifies you as a Christian nutcase. But it's very easy to say it's not a choice, it's a baby. You see what I'm saying? Where was I? What Professor Chemerinsky is putting out there for any of us who want to pay attention to what he wrote is that any constitutional guarantee now, no matter what it is, the right of assembly, the right to petition the government for redress of grievances, the right to choose your own religion if you are that insane. All of these rights now, they are constitutionally guaranteed, as was Roe v. Wade. But the Supreme Court ruled at midnight Thursday morning, or a little past midnight, or a little before midnight, they ruled that the rule of law no longer applies. This is the part that struck me in the face like a boot, like somebody kicking me in the face. Oh my God. Do you realize what this means? And I've said before, I'm no scholar of the Supreme Court. Hell, I have a hard time finding my way around the Constitution of the United States. But that ruling by these 5 Christian Nazis on the Supreme Court was so apparent, even I caught it. So now what? Hi, Truth Seekers. Mike Malloy here. As you know, we've switched formats and are now broadcast exclusively on the Progressive Voices Network. So that means you get fewer program interruptions, no corporate commercials, and lots of profanity. But our format change also means some of our radio listeners no longer hear the program. It's been a while since I mentioned our podcasts, so you may have forgotten that there is a way to listen to this program anytime you need a good dose of screaming. Visit MikeMalloy.com and subscribe to our podcasts. As a podcast subscriber, you can download the program to your mobile device and take me with you wherever you go. And if you have a friend who needs a dose of truth-seeking, you can give a gift subscription as well. That's MikeMalloy.com, and never miss a minute of the uncensored fun and frivolity.